Good afternoon. My name's Dr. Cameron Jones and I'm an environmental microbiologist. For any of you who tune into my social media each week, you know that Thursday is the day that I regularly do live streams on the topic of mold and water damage. I didn't think I'd be able to do a live stream this week for a very important reason, because I was called on to give expert evidence in a mold and water damage case. Now, I'm not able to talk about that case. I would love to here, and I possibly will down the track. But for today, I was let out because yesterday I presented my evidence and I wasn't able to remain today. So that got me thinking. I think today I should present something about expert evidence. And to begin the topic today, I want to be focusing on this topic of what you need to know about mold evidence and the rule in Browne versus Dunn. I want to make it very clear that I'm not a solicitor. I'm the expert, I'm the scientist, and people like me and others are often called on to provide their experience and their knowledge in writing and make findings regarding mold and water damage. And basically, I've presented, or what I'm presenting on, is something called the rule in Browne and Dunn. And why I think that this is highly relevant to people who follow my channel is that in many situations, when I'm called upon to do indoor air quality and mold inspection, the reason for that is that there is some type of dispute, either concerning the water and why it's there, the mold and why it formed, whether or not there is any mold to be concerned about, and whether or not the levels of water damage, dampness, and or mold could be considered a risk to the health and safety of any of the occupants or any stakeholders who might come into contact with that particular building or even the contents in there. And so, in many cases, we prepare expert reports, and in many cases, these expert reports are relied upon if a dispute can't be resolved amicably between the parties. And in getting ready, in preparing for this particular case, I was called upon by the legal counsel to meet with a barrister. And this is how come today's topic in this live stream even came about, because I arrived early to meet with a barrister and I decided to go to the downstairs ground floor coffee shop. And when I was paying for my coffee, I saw that there were a stack of these on the counter. And I thought, that looks interesting. Rules, regulations, that looks like that could possibly apply to me. So I picked one up, I started reading it, and I was able to read the whole couple of page newsletter before I had to go upstairs and meet with legal counsel, the barrister, and quite a few of the other experts, plus the applicant. So, because I'm not a solicitor, I want to highlight on these aspects that have been pointed out by Dr. Jason Harkness, who is a solicitor and barrister himself. And this is his email here, because I want to make no mistake, if this is at all relevant to you, listen to how this applies to myself as an expert from my perspective, but concerning any of the legal implications of what I'm about to say, please get your own legal advice or consult Dr. Jason Harkness himself. In any case, what I'm going to do, because as I mentioned, this is all about the context of how evidence will be used and presented. And as I said, in many disputes, often it's sufficient to provide this sort of qualitative and quantitative evidence, show this to the other party in the dispute in a good faith attempt to demonstrate the validity of your claims versus, in many cases, the opposing party's claims, which run counter to what you believe to be the truth of the matter. And these types of disputes, and where science becomes very important, really are fundamental tenets of where the truth lies in science and how science can be used to demonstrate greater or lesser towards the truth in an argument. In any case, and I'm going to be quoting very heavily from Dr. Harkness's newsletter, and basically what he says in his rule is that this Browne and Dunn applies to a particular set of circumstances, and these relate to how in a courtroom or a tribunal or some type of adjudicated hearing, what will occur between both sides. Usually there is an applicant and there is a respondent, and it is important to remember that the dispute will come down to the facts and what evidence is used to support those facts. And so Dr. Harkness writes about this very important case about Browne and Dunn, which I'm going to summarize very briefly in a minute, but I'm going to put down his 3 first points in his newsletter that states that the parties in such disputes, that a particular matter will be put to the opposing party for cross-examination, and that if any party intends to lead its own evidence on that matter that contradicts or challenges the evidence of the opposing party's witness, and if the party intends to invite the tribunal of fact to reject the evidence of the opposing party's witness in favor of its own. What does this basically mean? Well, I'm going to be talking about what this means with relevance to my own role as an expert, but I'm just going to briefly summarize this famous case of Browne versus Dunn. And essentially, James Browne was a neighbor who, for all intents and purposes, caused a lot of trouble to his neighbors. And what happens is that one of the neighbors was a solicitor, and that solicitor had the name of Cecil Dunn. So remember, James Browne is the neighbor that is causing the disturbance, and Cecil Dunn is the solicitor. So the solicitor drafted a retainer letter for his neighbors, and the intention of the retaining letter was that they would sign that, and that would allow him to represent them. And the statement was that Mr. Browne was seriously annoying the other residents and had done so for many months, even though they had endeavored to reach a peaceful resolution. So the letter authorized Mr. Dunn, the solicitor, to act for the neighbors and seek a court order against James Browne, causing the disturbance. And the reason for this is that the allegation was that why this became a hot topic and a legal case was that Mr. Browne became aware of this letter, and he stated that the contents of the letter caused reputational damage to him and were defamatory. And so this case really then became about one of evidence, because Mr. Dunn, the solicitor, called on 6 of his neighbors, and each of those neighbors who were now witnesses gave evidence under cross-examination that, number 1, Mr. Dunn had been instructed to act on their behalf. Number 2, that they also held a genuine grievance towards Mr. Browne, who was annoying them. Number 3, that the letter of retainer and its contents were in fact genuine, and that they had in fact signed the letter. This issue of evidence then comes down to whether or not the opposing party has had sufficient opportunity to present the alternative side of this argument. Of course, the alternative side to this is that maybe the neighbors didn't all agree to sign it, and that it's after the fact that they've then arrived at their testimony and all. And so there's some very interesting points at law, but I will leave that to the solicitors in the audience to discuss. I want to go on to how this relates to myself, because Dr. Harkness then lists 7 points about how this rule is actually applied. And certainly the first 5 points relate directly to how I myself as an expert conduct myself in a tribunal hearing and what one can expect. And certainly for any of you who are considering retaining experts who may have to provide evidence, make no mistake that the civil case will run along these lines to ensure that there is procedural fairness. And that's the whole point of what the role of solicitors is as one of their roles, to make sure that the proceedings occur in an ethical and unbiased manner. And I want to go through what Dr. Jason Harkness states, and because it's highly relevant about evidence, because the evidence will be looked at equally regardless of how emotive that evidence might be. And certainly in mold and water damage cases, the evidence is often highly emotive. So, number one, you need to be aware that Party A alleges that X occurred as part of its case against Party B. Then, Party B, as part of its case, denies that X occurred and that Y occurred instead. And so, typical examples of this in water damaged building disputes are that during the course of construction of my new home, you allowed it to become unreasonably wet, which has now caused mold to grow. And your argument may be that you feel particularly unwell, you had every right to expect a dry home during construction, and yet the other party, potentially the builder or some other person responsible for this, might allege that yes, it did become wet, but this is a normal event that occurs during construction, and that everything was built in a timely manner, and that there's sign off on each stage of the project. So whilst it's recognized that you have a grievance with regard to the water damaging some elements of the building, it doesn't necessarily mean that you now have a condemned property. Although that might be so, it then comes down to what evidence can be brought to bear on this. And this is where, make no mistake, that the information that you would seek to obtain from your experts will really depend. It's irrelevant whether you're Party A or B. The other party is going to have the opportunity to examine this. And Dr. Harkness goes on and states that if Party A calls their first witness, call them AW1, then counsel for Party A leading the evidence will state that X occurred. Similarly, the opposing party, if they intend to call a witness, call them B's witness first, number one, to give evidence that X did not occur and that Y occurred instead. And so there are a number of other steps, but you as the person retaining the expert needs to be aware that it is really almost, whilst it's possible for you to state that this is the outcome you want from your expert, at the end of the day, that expert's evidence needs to be strong enough to withstand scrutiny. And so it's very important to be aware of this whenever you're considering retaining witnesses, that what they have to say about perhaps the health and safety or the water damage or the potential mold will be dissected at some point. Now, why do we even need to have these rules? Well, this comes down to how the operation of the law occurs, and this means that there needs to be fairness to the witness. And again, I think that it's important that I keep this text up on screen, because it's important to highlight the fact that there needs to be opportunity given to the witnesses to consider both sides of the argument, not just what they've presented, but also where there is deviation in what is claimed by both parties. And so this is fairness to the witness, and this is where the rule of Browne versus Dunn, why this applies to so many cases that rest on evidence, and in fact is to some extent entailed within the Evidence Act. And then there is a second rule, which is fairness to the party who called the witness. And so this aims to avoid situations where a witness could be ambushed in a sense, so that they need to be aware of what the issues of dispute are prior to attendance. And thirdly, that there needs to be fairness of the whole process to the courtroom, and this is really a professional and ethical responsibility. Now, here is the author of this fantastic newsletter. I don't know Dr. Harkness at all. All I know of him is from his newsletter, which it's good that they weren't all picked up and that they were lying in the coffee shop, because now I've been able to amplify his message and bring it to your attention. I think it is highly, highly relevant for a number of reasons. Most importantly, and I will summarize, that when you are collecting information to support your water damage, mold, or adverse health claim with regard to the impact of mold and mycotoxins and other aspects of water damage in the built environment, you may need to get and seek expert opinion. These documents, in a sense, although you can focus on what is most relevant to your emotional claims, as they may be, with respect to the problem at hand and the exact circumstances that you find yourself in, all of this information that is written down will eventually be dissected and will be open to scrutiny. So bear that in mind, that this applies as a matter of how common law is applied in practice and in principle. In any case, my name's Dr. Cameron Jones. I do a lot of expert witness work. I prefer writing the academic papers and the lab reports that relate to your water damage building interior. However, from time to time, my reports get dissected as well, and make no mistake, those of other experts who are credible will need to withstand that level of scrutiny. So ask a lot of questions before you engage an expert. Ask them what their opinions are and how they would handle themselves when, in a sense, the alternative or the devil's advocate position is taken, because that's really what this rule of Browne and Dunn is as it relates to experts like myself. In any case, I wish you well with any disputes that you may be currently in or may find yourself in. Definitely, it's always my advice to seek the advice and counsel of experts and retain a legal practitioner to help you through your journey if you are having problems with another party. In any case, my name's Dr. Cameron Jones. It's been a short presentation. Obviously, you can find me here on Facebook. This talk will be going up onto YouTube later, and I shout out to Dr. Harkness for giving whatever talk he gave and leaving all of those flyers in the downstairs coffee shop. Anyway, bit of serendipity impacted on me, and I've passed this on. Bye for now.